Hey, and welcome back to Exposing Chicago Motor Cars. And we have another lawsuit out of the state of California.
Superior Court of the State of California for the County of Los Angeles. Holiday versus Chicago Motor Cars Corporation. Decision on court trial. This matter was tried as court trial, the plaintiff having waived his request for a jury trial. The witnesses. During the trial, the sole defense witness, Barry DeLisi, salesman for CMC, was first called as an adverse witness in plaintiff's case. DeLisi testified that prior to signing the contract, he and plaintiff Holiday agreed upon a $3,000 deposit. He also testified that the $50,000 payment by plaintiff was voluntary. DeLisi further testified that in his view, payment and deposit are the same thing, and they are all non-refundable. Yet Mr. DeLisi testified that he never read the terms and conditions of this contract and that prior to his deposition, he never heard the term liquidated damages. The court inquired of defense witness Barry DeLisi in order to better understand his testimony, including whether it was his belief that even a $200,000 payment after entering into the contract would be a deposit. Mr. DeLisi did not know the answer to the question despite the fact that he seemed convinced that a $50,000 subsequent payment was a deposit. Plaintiff Terrence Holiday testified that the parties agreed on a deposit of $3,000 at the time he signed the agreement, and that DeLisi told him that a $3,000 deposit would be sufficient. Holiday further testified that the $50,000 was not discussed as a deposit under the agreement, but was offered later as a voluntary good faith payment when his back was injured. He testified that he had intended to go to Chicago to inspect the vehicle, but could not do so with the back injury. Plaintiff contends that his purpose of offering the $50,000 was to make a partial payment to hold the deal. Holiday testified that there was no discussion that $50,000 was necessary to secure the deal, and no discussion regarding the $50,000 as liquidated damages. Holiday also testified that DeLisi specifically told him that the $50,000 would be refunded if the transaction did not go through. The court finds, after considering the evidence and the arguments of the counsel, that the parties negotiated for and agreed upon a liquidated damages provision of $3,000. The contract was entered into on May 25, 2010, and the deposit reflected in the documentation was $3,000. The evidence demonstrates that the parties negotiated for and agreed upon a $3,000 deposit. Trial Exhibit 2 reflects a bill of sale dated May 25, 2010, and prepared by Chicago Motor Cars, which references the $3,000 as a previous deposit. The court finds that there was no discussion of anything but a $3,000 deposit prior to the signing of the contract by plaintiff on May 25, 2010. Furthermore, although defendant argues that any deposit means more than one deposit could be made, the first issue is what deposit was agreed upon at the time the contract was made. As set forth above, the court finds that the deposit agreed upon at the time the contract was made was $3,000. Moreover, interpreting the contract, the court finds that if the parties intended more than one deposit at the time they entered the agreement, then the word deposit would logically be deposits. The court further finds that the issue of the $50,000 good faith payment did not arise until at least a week after the contract was signed. There is no evidence that the $50,000 payment was negotiated as liquid damages prior to entering into the written contract, and no evidence that $53,000 was discussed as a deposit. The message wired with the $50,000 payment dated June 1, 2010 had the following text: "Hold deal." Trial Exhibit 16. Furthermore, the written contract was never revised to indicate anything other than the $3,000 deposit. The court finds no persuasive evidence that the parties agreed that $53,000 was a valid or reasonable estimate of damages, and no evidence that the $50,000 payment was negotiated at all. The sole witness for defendant, Barry DeLisi, was not always consistent or credible in his testimony. He changed his story between his deposition testimony given under oath and his trial testimony. Specifically, the court notes that Mr. DeLisi's trial testimony was quite different from the deposition testimony on the $50,000 and different from the defendant's answer in In his deposition, DeLisi testified under oath that from the first discussions, the defendant would not accept only a $3,000 deposit for the car and required more. DeLisi further testified at his deposition that he and Holiday agreed upon a $53,000 deposit prior to entering into the contract on May 25, 2010. See settled statement of 7/12/12. DeLisi's testimony on this subject changed completely at trial to the extent that he then contended that the $50,000 payment was subsequent to agreeing on the $3,000 deposit, but still could not recall the date of the conversation regarding the $50,000. In addition, the documents introduced as evidence at trial were also inconsistent with DeLisi's deposition testimony, in that the documents support a $3,000 deposit at the time of signing the agreement, bill of sale, trial exhibit 2, and the $50,000 was not wired until a week after the agreement was signed. Likewise, at his deposition, DeLisi testified plaintiff never told him of a back problem, but DeLisi's own email to plaintiff contradicts his statement, and DeLisi backed off of this testimony at trial. Among other things, DeLisi's trial testimony about his call to the Beverly Hills car dealer doesn't make sense. DeLisi's impaired his credibility when he testified that he called that dealer because he was trying to locate Mr. Holiday, but later testified that the only thing DeLisi said to the car dealer was to ask if Holiday was a customer of the dealer. DeLisi never asked how to get in touch with Holiday, which was purportedly his purpose for the call. In short, DeLisi's testimony was inconsistent and contradictory on key issues, and therefore not very persuasive. Although defendant for the first time at trial tried to characterize the $50,000 as an oral modification to the written contract, the court agrees with the plaintiff that there was no showing by the defendant that there was an oral modification. Defendant did not establish an oral modification under Civil Code Section 1698. There was no showing that there was a meeting of the minds and no showing of consideration. Nor could DeLisi even recall when the conversation regarding the $50,000 occurred, so his testimony did not support an oral modification. His testimony before trial was that it occurred before signing the contract, which would mean it was not an oral modification. His testimony at trial was that he could not recall when the conversation occurred. In addition, DeLisi further testified at trial that if Chicago Motor Cars changed a deal, then they would send out a new documentation to reflect the change, but no new documentation was sent out after the purported oral modification. And no document shows $50,000 to be a deposit, and no document shows that the $50,000 was to be non-refundable. Moreover, it is difficult to follow how there could have been an oral modification to liquidated damages that occurred after entering into a written contract, given that the law is clear the liquidated damages must be set at the time the contract is entered into. Furthermore, even if there had been an oral modification increasing the liquidated damages to $53,000, the defendant needed to establish how a $53,000 liquidated damages provision is not a penalty. From the evidence presented at trial, it seems clear that any provision for $53,000 in liquidated damages was not negotiated for at the time of signing and was not reasonable given the potential damages under the circumstances of the sale of this automobile. Thus, a $53,000 liquidated damages provision would constitute an unauthorized penalty under California law, rendering the liquidated damages provision void. In this dispute, each side contends the other breached the contract. To establish a breach of contract, one must establish the following elements. 1. Existence of a contract. 2. Plaintiff's performance under the contract. 3. Defendant's breach of the contract. 4. Damages. The court finds that the contract was the written purchase agreement signed by the plaintiff on May 25, 2010. There is no convincing evidence that there was an oral modification of that agreement, and no convincing evidence that there was a meeting of the minds on any such oral modification. The court finds that the liquidated damages provision of the written purchase agreement is valid and enforceable, and the liquidated damages agreed upon were $3,000. Thus, plaintiff has established that the defendant has breached the contract by failing to return the $50,000. Plaintiff is entitled to a return of the $50,000 good faith payment less the $10 charge for the wire. Defendant, on the other hand, has not established breach of contract because defendant has not shown any damages. Defendant is entitled to keep the $3,000 deposit as liquidated damages under the written contract, but not entitled to keep the $50,000 good faith payment. Therefore, it is ordered, adjudged, and decreed that defendant Chicago Motor Cars Corporation shall take nothing by way of its cross-complaint, and its cross-complaint is dismissed with prejudice, and that plaintiff Holiday shall recover from defendant $50,000 less the $10 wire fee plus the cost of suit in sum of, not disclosed, pursuant to a cost bill to be filed pursuant to California Rule of Court 3.1700, dated August 17, 2012.